Well, hello everybody. We're here today to talk about the Sixties Scoop Settlement and to answer some of your questions that you might have about it. My name is Kenn Richard. I'm right now the Executive Director of Native Child and Family Services of Toronto. My own background is I'm from the French and Métis communities in the Red River Valley and have been, I think, an activist in child welfare for a great many years. And I've had the privilege of acting as an expert witness on the settlement itself, so I've been very privileged that way. We're here with two esteemed and knowledgeable people, and I want them to introduce themselves. Let me start with you, Raven.
Hi, my name is Raven Sinclair. I'm a professor of social work at the University of Regina in Saskatoon, and I'm also an adoptee, a survivor of the Sixties Scoop. I've been interested in this area for, ever since I started university in the early 80s, and have been involved in meeting with adoptees across the country and doing research, gathering the stories. So all of the issues around the Sixties Scoop are very dear to my heart.
Hello, I'm Jeffrey Wilson, and I'm a lawyer, and I am the lead counsel in the case known as Brown versus Canada. And I started work on the Sixties Scoop with Chief Marcia Martel 17 years ago. And we are now at the point where we have a settlement.
So Jeff, could you please give us an overview of that settlement?
So as a result of a decision of a judge of the Ontario Superior Court in February of 2017, like any decision, there was a victory for one of the parties, and this was a victory for the representative plaintiff, Chief Martel, and the class in Ontario. Canada elected to engage in settlement discussions. Settlement discussions took place across the country. It resulted in a settlement finalized at the end of November. That settlement needs to be approved by two courts, one in Saskatoon on May 10th and 11th, and another court in Toronto on May 29th and May 30th. Any person interested in attending can come to either hearing. Any person who wants to object can come to the hearing and object. The settlement provides for compensation to each eligible claimant. It defines who are the eligible claimants. It very importantly provides for a foundation which will receive $50 million. People do not need a lawyer under this settlement to file a claim for compensation. It will be one page, very simple. You don't have to pay a lawyer, and you will fill out that form if you are an eligible member and receive your compensation. When will you receive your compensation? Because everybody in any court case asks that very legitimate question. In this case, it's a little different because it depends how many people are eligible. The amount of money dedicated to compensating is $750 million. Over the next 9 months, if the settlement is approved, people will come forward. At the end of 9 months, we will know how many people there are, and then there will be distribution, very likely in 2019. One other point, why you can't decide, is in the case in Saskatoon, a person can opt out, which is different than objecting. Objecting means, I'm objecting, I don't like this deal or settlement. Opting out is saying, I don't want to be part of it. Even though I'm eligible, I do not want to be part of that settlement. And we can talk more about that if you want. That process of opting out does not take place until and if the settlement is approved in Saskatoon and then in Toronto.
Thanks, Jeff. Now, Raven, you've been talking to a lot of people. What are some of the questions that are coming up?
The first one that I've been hearing a lot from across the country is a concern around a lack of consultation. So the question would be, why has there been no consultation in terms of getting to the point of the settlement in principle? And so that's what people are asking. The second one is that there's been concern about the amount of the settlement. So, each claimant they're anticipating between $25,000 and $50,000. And a lot of people are saying, well, I went through lots of trauma and turmoil, and how is that supposed to compensate me for my experiences? So that would be the second question, is getting some clarity around that. And then the last one would be, even if people have all the facts and all the information, they've gone to 60scoopclaim.com and they've looked at all the frequently asked questions, and they're still not happy. They still think that, even my cultural loss should be compensated at a higher amount. What can they do? Is there any recourse that they have there?
Let's take these questions one at a time. So regarding consultation, what process did we undertake to get to this settlement, to get to this point in time?
My understanding of the case itself is somewhat limited, but what I understand is that because it's a lawsuit and it was Chief Martel's win, and so it's not really a process where consultation would take place. The negotiations between the legal team and the federal government to get to the settlement in principle, I mean, that's something that they did, and I just personally didn't see where in a legal case where there would be sort of a mass national consultation. What I'm hoping to see or understand is that there will be more consultation in terms of the Healing Foundation piece. But a legal case generally, from as a layperson, we generally aren't consulted on sort of legal outcomes. Jeffrey, maybe you can add to that.
The person who was key for consultation was Chief Martel, because she was the representative plaintiff. And it was a settlement of a legal case. Bear in mind that we started this 13 years ago, that we went throughout the communities throughout Ontario, that we discussed with very brilliant people the concept of a 60 scoop. And when we started this case in 2004, this idea of 60 scoop, while it was known in academic circles, it had no existence within the annals of jurisprudence. It was like inventing an entirely new creature. So there was significant consultation throughout the process of 13 years, culminating in the decision in 2017. Then in terms of the settlement discussion, each of the lawyers sitting at the table was under the duty to have regular consultation with their clients in respect of legal claims towards the settlement. But you're right. Once and if the settlement is approved, then we will begin, I'm hoping, the process of Canada-wide consultation on what does the foundation do.
Let's just speak about the compensation a little bit. Is it a fair amount that's being talked about? What about those who experienced physical and sexual abuse?
Well, again, this is where my understanding is that this particular case is just about cultural loss. I know as a researcher and knowing adoptees across the country that there's been, there's been some really good stories, but then really, really horrific ones. And this law case doesn't encompass those issues. Those issues are going to be separate legal actions, probably at the provincial level. Is that right, Jeffrey?
A person who legitimately grieves for being physically or sexually harmed can still sue for that harm against a provincial authority, a Children's Aid Society, a superintendent, or the provincial government. This case is solely in respect of loss of culture, loss of cultural identity. Is $25,000 to $50,000 enough for that loss for each person? Who knows? I don't think it is. But against the backdrop of what the law would reasonably provide, it is clearly on the high side in terms of looking at what the law would provide as compensation. And because this is a class action, you cannot look at it solely in terms of the individual claims. You have to look at it in terms of the collective amount. The collective amount is $750 million. I'm told that's the fourth highest settlement amount in class action history in Canada.
There still are some people, I think, that while they want the compensation and are well entitled to it, may feel anger and frustration. What do you advise them to do? I guess I pose that to either of you.
Come work with the foundation. One thing this settlement provides, which we could never achieve if we went to court, because no judge has the jurisdiction to order it, is a foundation that has an initial contribution of $50 million. That's where the real work will happen, listening to people who are understandably very angry, to make sure that what happened in the best interests of children, because that was the lingo, your field's best interest of the child, was the lingo that justified the 60 Scoop. So to make sure that what happened in the best interests of children, First Nations children, can never happen again. So we want to embrace all of those who want to make a contribution, to use their energy so that we can say loud and clear, never again will we permit this to First Nations children or to anybody's children.
As an adoptee, you know, I have a lot of empathy for people that experience the frustration. And I understand. I really want people to understand the difference between this federal settlement in principle for cultural loss, and separating that from any abuses they've experienced. And I was a victim of abuse as well in foster care, and so I have some investment in seeing reparation for that, and intend to pursue a provincial claim as well. So it makes sense to me when I hear the stories that there is a lot of frustration and anger out there, and a small settlement, even if in legal terms it's a solid, a good outcome, I think some people are still going to not necessarily be happy with it. And so I'm really putting a lot of hopes in the foundation that we can have consultation and know what adoptees across the country want in terms of helping them to feel better, whether it's language lessons, land-based culture camps, research, counseling, the availability of therapeutic services.
And not just adoptees in the foundation.
Adoptees.
Crown wards,
Yeah.
any child of First Nations,
Right.
Métis, status, non-status, can seek and receive assistance through the foundation.
Yes, and I just used the word adoptee, but in my mind I'm always including foster kids as well, foster survivors and those who are made crown wards. But yeah, I have a lot of hopes in the foundation that we can create something that will really help people to achieve some recovery from those really harmful experiences. But I understand, that there is frustration and anger, and rightfully so.
So just drawing this to a bit of a close, is there a particular message that either of you want to give to the folks who will be watching this video? Is there one final thing you'd like to say?
I really want people to have all the information. And, early on I didn't have much information, and I was a little cranky about what I was hearing, which was limited and sometimes was inaccurate information. But I know, I've recently went to the sixtiesscoopclaim.com site, and there's a frequently asked questions there, and a lot of my questions got answered there. And then, I've been fortunate to be able to have discussions with people who, know the ins and outs of the whole case. But I think that it's really important for people to have as much information as possible, and it's okay to object. It's okay to not be happy with the settlement and still be a recipient of it. If people decide, no, I'm just not going to go there, and they decide to opt out, that they understand they won't receive compensation, and they will need to pursue their own suit and basically start from scratch. And I just really want people to know that, because they need to know what their rights are and what they can do to be compensated. Mm-hmm. It's important to me to give thanks to Marcia Brown, because one of the ways that I have come to understand the case is that she didn't have to insist that it be a national settlement. And were that the case, we'd be sitting back watching Ontario claimants receive their compensation, and the rest of the provinces would be, somewhere in the process pursuing their claims. So I just want to acknowledge her generosity of spirit and her commitment to survivors everywhere for this incredibly generous gesture. I'm very grateful.
What about you, Jeff?
Well, for Chief Martel from the very beginning, her purpose and our objective, along with Robert Commander when we started it, one was an adoptee, the other a Crown Ward, was to make sure, as I said, that what happened cannot happen again. And we have a foundation, and I encourage everyone to come and participate and be a member of the foundation to essentially raise the consciousness of the Canadian community, First Nations people and non-First Nations people, because there were many non-First Nations people who were deeply affected by the 60s Scoop, so that there will be a consciousness raising within the industry of child welfare. That does what the chief wanted by starting this action 9 years ago, and Mr. Commander, which is can happen again.
Thank you both. By way of my closing on this, just to take off to what you just said, Jeff, yes, the paradigm of child welfare has historically been one of child removal. We know that that has been at best a very limited way to actually deal with the issues. And indeed, there are a number of folks, and this has been determined in this settlement, who suffered as a result, and that should be recognized and compensated. But to me, it's, as somebody who's been a professional in child welfare, you folks can provide us with the impetus to really push that change a little bit further. So to me, it's a broader issue, and God bless those who will receive compensation. You're acting as a symbol to the rest of us in terms of we can't, as a state, get away with this, and I'm very pleased to have seen that. So I'm just going to conclude this. It's been a really good discussion. I hope that it was useful to those of you who are watching, and I want to remind you that you can go to 60sScoopClaim.com and get further information. You may be seeing this video on that website itself. So have a good day, and hopefully we'll talk later.
Thank you. Thank you.